Hi, Attorney Jennifer Witt here with the Witt Law Group, talking about Miranda warnings today. A lot of people who watch true crime TV or movies, you're pretty familiar with the Miranda Rights, which come out of Miranda versus Arizona. And the court in that case said, if you're being interrogated in the United States, here are some constitutional rights you have, and you should be notified of those rights. So everyone probably is familiar. It's the right to remain silent. It's to be notified that if you make statements, those statements can be used against you. You have the right to an attorney, and if you can't afford an attorney, one will be appointed for you. So most people can get that far. They've heard of Miranda Rights or the Miranda warnings that officers are supposed to give when somebody is being arrested. The biggest issue with Miranda is, from my perspective, is most people don't know when they apply and what is the remedy when there's a violation. So when do they apply? Miranda warnings or rights apply when you are being, there's a custodial interrogation. The key word is, are you in custody? And custody doesn't necessarily mean you have, you're being handcuffed and you're going to jail, or you're in one of those little rooms that you're being questioned, like in the movies. They bring you into the station and question you. It can be on the side of the road. It can be in a park. It can in a store. It can be a lot of places. The key to it is, are you free to go right there? And this gets a little tricky because there are other stops called a Terry stop. And I won't get too much into Terry stop, but Terry stop or even traffic stops, the courts have always said, there's a wide latitude for an officer to do kind of a preliminary investigation. They're really trying to confirm or dispel their reasonable suspicion of a crime occurring, has occurred, will occur, and they have to ask a few questions. That you often see that where, hey, some lady in a red dress and a black jacket, I saw her breaking into the back of all the houses in my neighborhood. And lo and behold, I'm standing on the side of the road, it's 10 o'clock at night, red dress, black jacket, and an officer is going to come up and be like, hey, what are you doing here? Do you live in the neighborhood? Those kind of questions, the courts say, that's fine. They don't need to read me Miranda. They're trying to decide, hey, is this lady in the red dress the lady we're looking for, or is this her house? This is, it's reasonable. She's standing in front of her house. So they're dispelling or confirming reasonable suspicion of something they're investigating. But when you rise to a custodial interrogation, you really aren't free to go. So, and that gets a bit nuanced because, at least in Washington State, you kind of aren't really. It's interesting. You're technically free to go, but not really. If an officer says, hey, I need your ID, or you're, on the side of the road, give me your license and identification, and you certainly can't turn on the engine and take off. But the courts say that's okay. That's that limited interrogation, and the challenge with that is during that stop is usually when something escalates to, say, a DUI stop, where an officer is gaining information. Perhaps they smell the odor of intoxicants. You'll see that in every DUI report. I smelled the odor of intoxicants as I came to the window. The driver had bloodshot, watery eyes. So there are certain statements that are going to be in there, and the officer is collecting that information, mentally, and they're basically taking the information they're gathering and trying to get to the probable cause standard. Do I have probable cause to arrest this person on suspicion of DUI? So it gets a little nuanced in circumstances like that. Other times it's very clear when you're going to arrest a person or when a crime has occurred and you need to read Miranda right out of the gate. So again, certain crimes, very clear, sometimes it's not. But let's say the officer does read Miranda and you keep talking. That's another problem. We see this quite frequently in DUI cases where the individual invokes their right to remain silent. They say it. I don't want to talk to you. I don't talk to cops. I'm not talking. I want my lawyer. They get in the back of the police car and they start talking, and they can't stop talking, and they have essentially re-engaged. So you have waived your Miranda rights. And oftentimes people don't realize they've done that. And the officer, you're like, man, this is such a bummer. I'm going to jail. I've got my kids at home. I need to get home. I just went out for a few beers with friends. And they're telling this story. And the officer's, really, you had a few beers? Where'd you go? Oh, well, I had a few beers and a couple shots. And well, those statements are coming in now. You have re-engaged. You have waived your rights. So that's one situation where people often don't realize you opened the door, you re-engaged and waived your right to remain silent. Then let's say the officer didn't read you your Miranda rights, but you're in the back seat talking, and what's going to happen? People often call us and say, well, good news, they didn't read me Miranda, so I'm assuming this case will get dismissed on Monday. No such luck. Miranda rights, the remedy, and this is what's critical. So if you're thinking Miranda is a big deal in your case, there's a small chance it could be, but in most cases, the remedy is simply suppression of those statements at trial. So you'll have to argue that there was a violation. Assuming there was a violation of your Miranda rights, the most likely result will be those statements will not be allowed to be discussed by the prosecution in trial. So, if on a DUI, do you really need the statements saying, hey, I went out with my buddies and had 6 beers? No, they're going to have the dash cam footage of you weaving in the lane. They may have your breath sample. They have you, the odor of intoxicants, the bloodshot, watery eyes. Maybe somebody called in 911 and, ID'd a vehicle with poor driving. So lots of ways to prove a DUI. So suppression of the statements don't really matter in that particular fact pattern. There are some DUIs that could matter, but most of the time it doesn't matter. So the remedy, while you have a remedy, it doesn't often help in a case. It would be very, very rare that a prosecutor would go forward on a case where the only evidence they have is your statements, right? So So the suppression of the evidence in that case, those statements, would be key to getting the case dismissed, but it just doesn't really happen. And I could get into a lot more of how we bolster those cases, how that's relevant, but it is important to know, because oftentimes people will have this lag time, where they have convinced themselves and their other friends who watch, To Catch a Predator or whatever, who think they know criminal procedure and the rules of evidence, are like, yeah, man, that's a slam dunk. They didn't read your rights. Your case is getting tossed on Monday or next week or at your pretrial. It's not happening. So be aware that it's oftentimes, the reason I try to put these out is there's so many proactive things you could be doing to help get your case resolved, which could end up in a dismissal in another negotiated fashion, or a lesser charge, or just something more beneficial to you if you understood what is relevant and what is not relevant to a case moving forward or getting dismissed. So I hope that helps you. Remember, when you're talking about Miranda, were you technically in custody at the time that you made the statements that you want suppressed? So basically, our Miranda warnings invoked at that time? They should have been read to you. And number 2, does the remedy really help you? Suppressing your statements, not to mention if you do take the stand and you say something contrary to those statements, the prosecutor actually still gets to bring them in and impeach you with them. So, a lot of nuanced things here that you really need a very experienced criminal defense attorney to talk that over with. Make sure you do so in the state or city, county where you're charged, preferably, always the state. But my preference, I think you really need to drill down on an attorney who practices in the area where you were charged, because all of the options can be so different, across the state as to how a prosecutor manages their case. So I hope that's helpful. Again, very common topic, misunderstood topic that can sometimes get people into a bit of trouble because they wait so long. So I hope that's helpful. If you like this content, please hit like and subscribe, and thank you for watching.